It is now week 3 of the Waukesha parade trial. Witnesses today recounting the moments leading up to the arrest of Darrell Brooks, the man accused of driving through the Waukesha Christmas parade last November.
Joining us tonight to discuss today's developments are legal analyst Craig Mastantuono, our attorney from the Mastantuono Coffee and Thomas Law Firm. And Craig, we want to start with the moment that we saw in the courtroom where the judge cut off Brooks and during many of his objections.
How would you describe Mr. Brooks's haircut today?
Objection. I don't consent to being called that name.
Oh. Sir, I understand your objection. Please do not interrupt with that further so that the questioning of the witnesses may continue. You may answer.
If you say that name, I'm objecting.
And the jury will disregard the objection if it's solely for the name purposes.
So you heard the objection there. Today in court, we saw a body camera video of Brooks's arrest where he tells the officer his name is Darrell Brooks. So what does that do to his argument about being called Darrell Brooks in court?
Look, on one level, not make much sense to the jury. That's what it does. On another level, I think what Mr. Brooks is grasping at is that to consent to jurisdiction, given this sovereign citizen defense he keeps pushing, would be to accept the court's referencing him by name. And so he's pushing back on that to make sure his record, as he wants it, is clear that he's not accepting or consenting to the court's addressing him like that in court.
And before witnesses were called today, the district attorney went over a pretrial offer that they made to the defense in July. That was before Brooks decided to represent himself in court. Brooks claims he never got it. What does that do? Is there any risk of mistrial or delay?
You know, could a later claim of not having been provided pretrial ineffective assistance or effective assistance of counsel come up based on the lack of his receipt of a pretrial offer? It's possible. That would have to be established. This is Mr. Brooks's assertion now. And then the offer was later given to him again today out of an abundance of caution. It's not likely, given what the offer was, that Mr. Brooks would have accepted it. It was plead to just about everything and accept 6 consecutive life sentence recommendations by the state.
And the plan is to take the jury to see the SUV. That is unusual. How does that work?
It's very unusual to go to a scene or to go outside of the courtroom with the jury during a trial. How it works is with a lot of security, because Mr. Brooks himself is also, who has the right to be present at all trial proceedings, is also transported to wherever the jury is brought. They're all in proximity of each other outside of a secure setting. It takes a lot of security. I've done one of these a couple of times in various scenes. And usually it's a scene you're looking at, not a vehicle, as it appears to be in this case.
And you were inside the courtroom today. What can you tell us about what it was like inside?
Well, you get a perspective as to Mr. Brooks's proximity to both the prosecutors that he's working against. They're about 6 or 8 feet apart. These are newer courtrooms in the Waukesha County Courthouse Annex, so they're a little tighter than perhaps the larger courtroom where, like, the father and son Oswald bank robbery team from the 90s were tried, or some other, Mark Chmura, some other big cases in Waukesha County. So it's a little tighter quarters, and it's just a little bit more unusual when you have somebody representing themselves in a homicide case. There's several sheriff's deputies there to watch him.
And testimony resumes in the morning. Craig, thank you so much for joining us tonight.
Thank you.
Thank you.